Hello everyone, welcome to another education seminar. Today we are going to talk about a famous case study, that is Donoghue versus Stevenson. The Donoghue versus Stevenson, the fact was on August 26, 1928, Mrs. Donoghue's friends bought her a ginger beer from the meadow Café in the Paisley. She consumed about half of the bottle, which was made of dark opaque glass, when the remainder of the contents was poured into the tumbler. At this point, the decomposed remains of a snail floated out, causing her alleged shock and several gastro-enteritis. Mrs. Donoghue was not able to claim through a breach of warranty of a contract. She was not party to any contract. Therefore, she issued proceedings against Stevenson, the manufacturer, which snaked it way up to the House of Lords. So, what is the issue here? The following issues were raised in this case. 1. Was the manufacturer of the ginger beer aware of the defect in the product that made it unfit to consume, and was it fraudulently concealed from the consumer? 2. Could the product be classified as dangerous per se, and was there a failure on part of the manufacturer to warn the consumer of the same? 3. Would an action of negligence be applicable in light of the fact that there was no contract formed between the plaintiff and the manufacturer? Whether the manufacturer owed Mrs. Donoghue a duty of care in the absence of contractual relationship contrary to established case law. Donoghue was effectively a test case to determine if she had a cause of action, not if she was owed compensation of any damages suffered. Then come reasoning. What was the reasoning beside this? Beside the judgment the judges give us. The question arises from the end of the previous activity is how logical and legal the reasoning actually is. We can see that the more logical and certain forms of reasoning are presented more clearly by the lords, while less certain forms are more hidden. But Lords Atkin and Buckmaster make many choices when they came to their complete opposite conclusion. Choices as to which case to look at, which part of those cases, where to find their ratio decided, how to categorize them, what are the most important facts, how they relate to the current case, and so on. They also have economic, social and moral principles in mind, which influence their choice and exist outside of a strict legal reasoning process. In light of this, is there really any certainty as to what the judges will declare the law to be in any new case based on previous case and legislation? Judgment. The hall found for Mrs. Donoghue, who is the leading judgment delivered by Lord Atkin in 3-2 majority with Buckmaster L and Tomlin L dissenting. The ratio decided of the case is not straightforward. Indeed, it could be interpreted as narrow as to establish a duty not to sell occu bottles of ginger beer containing the decomposed remains of a dead snail to Scottish widows. Read more broadly, the decision has several components. First, negligence is distinct and separate in tort. Second, there does not need to be a contractual relationship for a duty to be established. Third, manufacturer owes a duty to the consumer who they intend to use their product. However, the primary outcome of Donoghue and what it is best known for is the further development of the neighbor principle by Lord Atkin, who said the rule that you are to love your neighbor becomes in law. You must not injure your neighbor, and the lawyer questions, who is my neighbor? Receive restricted reply, you must take reasonable care to avoid acts or omission which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? In law is my neighbor. The answer seems to be persons who are so close and directly affected by my act that I ought reasonably to have them in contemplation as being so effective when I directing my mind to the act or omission which are called in question. Mrs. Donoghue had proved that avertment that she had a cause of action in law. Then what we learn from this? What is the conclusion? The conclusion: Donoghue versus Stevenson does successfully sets a benchmark for the standard of duty of care. However, with increasing legal conclusions, the set standard started become too simple. A more elaborate 3-step neighbor test was established in Capro Industrial PLC versus Dickman 1990. The test, however, had its basis in the original principle of Lord Atkins. Other cases have further developed this principle. The impact of Donoghue on tort law cannot be underestimated. It was a watershed moment, effectively establishing tort as separate from contract law. However, it is important to remember that Donoghue versus a milestone in a new principle which needs refining. As Lord Reid said, the well-known passage in Lord Atkins' speech should, I think, be regarded as a statement of principle. It is not to be treated as if it were a statutory definition. It was required qualification in new circumstances. So what we find, what the outcome from this? The outcome of Donoghue versus Stevenson established several legal principles and precedents. Negligence. Firstly, the House of Lords ruling affirmed that negligence is a tort. Plaintiff can take civil action against a respondent if the respondent negligence caused the plaintiff injury or loss of property. Previously, the plaintiff had to demonstrate some contractual arrangement of negligence to be proven, such as the sale of an item or an agreement to provide a service. Since Donoghue had not purchased the drink, she could prove no contractual arrangement with Stevenson. Yet Lord Atkin's judgment established that Stevenson was still responsible for the integrity of his product. Duty of care. Secondly, the established that manufacturers have a duty of care to the end consumers or users of their product. According to Lord Atkins, ratio descending a manufacturer product which he sell reach the ultimate consumers in the forms in which they left in owes a duty to the consumer to take reasonable care. The precedent has evolved and now forms the basis of law that protects consumers from contaminate or faulty goods. This protection begins as common law, but many have since been codified in legislation such as the Trade Practice as Commonwealth 1972 neighbor principle. Thirdly, the Donoghue versus Stevens case produced Lord Atkins' controversial neighbor principle, which extends the tort of negligence beyond the tortfeasor and the immediate party. It raised the question of exactly which people might be affected by negligence action. In Donoghue case, she had not purchased the ginger beer but had received it as a gift. She was a neighbor rather than a party to the contract. Atkins said of this principle, you must take reasonable care to avoid act or omission which you can reasonably foresee would be likely to injure your neighbor, who then in law is my neighbor. Then the answer seems to be persons who are so close and directly affected by my act that I ought to have them in mind when I am consider these acts or omission. Thank you. That was for today.